Welcome to our new video. Today we're diving into some of the most asked copyright FAQs, like translation rights, infringement penalties, and what legal remedies are available to protect your creative work. So if you're a creator or business owner, this video is for you. Copyright Frequently Asked Questions Part 7. Question 43. Can any person translate a work without the permission of the owner of the copyright in the work? Answer: no. A person cannot translate a work enjoying copyright without the permission of the copyright owner. Translating a work is considered a derivative work, and under copyright law, creating a derivative work requires the authorization or consent of the copyright holder. Why is permission required? 1. Derivative work protection. When someone translates a work, they are creating a derivative work, a new version of the original work adapted into a different language. Since a translation is an adaptation of the original, it is covered under the same rights as other derivative works. As a result, the copyright holder of the original work retains the exclusive right to authorize or prohibit such adaptations. 2. Exclusive rights of copyright holders. Under the Copyright Act, the author or owner of a copyrighted work has exclusive rights to reproduce the work, create derivative works, which includes the right to translate the work into another language. Without permission, translating the work would be a violation of these exclusive rights. Question 44. What is the term of protection of copyright? Answer: the general term of copyright protection is 60 years. However, the duration of protection depends on the type of work and specific circumstances, as explained below. For literary, dramatic, musical, and artistic works, the copyright protection lasts for 60 years from the year following the death of the author. Example: if an author dies in 2020, the copyright protection will last until the end of 2080, 60 years after the year of death. Note: the copyright duration is calculated from the end of the year in which the author passed away, not from the year of their death. 2. For cinematograph films, sound recordings, photographs, and other works. For works like cinematograph films, sound recordings, photographs, posthumous publications, anonymous and pseudonymous works, and works of the government or international organizations, the copyright lasts for 60 years from the beginning of the calendar year following the year of publication. Example: if a cinematograph film is published in 2020, the copyright will last until the end of 2080, 60 years from the beginning of 2021. 3. Works created by government and international organizations. For works created by the government or international organizations, the copyright protection lasts for 60 years from the beginning of the calendar year following publication. This applies to works produced under the direction or control of government entities or international organizations. Example: a government report published in 2020 will be protected by copyright until 2080. 4. Special cases: anonymous and pseudonymous works. If the author of the work is not known, and it is published under a pseudonym or anonymously, the copyright lasts for 60 years from the date of publication, not from the death of the author. Posthumous works. If a work is published after the death of the author, the copyright term is still counted as 60 years from the beginning of the year following publication. 5. Derivative works. If a derivative work, e.g., a translation or adaptation, is created, the copyright term for the derivative work starts from the date of creation or publication of the derivative work, depending on whether the original work is still under copyright. 6. Special provisions for certain types of works. For example, computer programs. Computer programs are also treated as literary works under copyright law, and the term of protection is the same as for literary works: 60 years from the death of the author, or 60 years from publication if the author is anonymous. Question 45. Which regulatory body oversees copyright matters and enforces copyright laws? Answer: the primary regulatory body for copyright matters in India is the Copyright Office, which operates under the Ministry of Commerce and Industry. The Copyright Office is responsible for handling various copyright-related functions, including registration of copyrights, maintaining records related to copyrighted works, enforcing and administering the Copyright Act, 1957, providing guidelines and information regarding copyright laws. Key bodies involved in copyright enforcement and oversight. 1. Copyright Office. The Copyright Office is the central authority for administering copyright laws in India. It is responsible for registering works, managing records, and overseeing the compliance with the Copyright Act, 1957. The Copyright Office is located in New Delhi and is headed by the Registrar of Copyrights. It provides registration services and handles disputes related to copyright infringement. 2. Copyright Enforcement Advisory Council, CEAC. The CEAC is an advisory body that assists in ensuring effective enforcement of copyright laws and protection of creators' rights. It advises the Government of India on matters related to copyright protection and enforcement strategies. The CEAC includes representatives from various sectors like the government, industry, and copyright owners, providing a platform for addressing the challenges faced in copyright enforcement. 3. Copyright Board. The Copyright Board is an adjudicatory body that resolves disputes related to copyrights. If there is any dispute regarding ownership of copyright or infringement cases, the Copyright Board is responsible for adjudicating such matters. It also deals with appeals related to decisions made by the Copyright Office. Question 46. Which acts are commonly considered copyright infringements? Answer: copyright infringement refers to any violation of the rights granted to the copyright holder under the Copyright Act, 1957. The following are some of the commonly known acts that are considered infringements of copyright. 1. Making copies for sale or hire. Reproducing a copyrighted work without authorization and selling, renting, or letting it for hire constitutes an infringement. Example: copying a book, film, or music album and selling it without the copyright holder's permission. 2. Performing copyright works in public without permission. Performing or presenting a copyrighted work, like a play, musical composition, or dance, in a public setting without the permission of the copyright holder is an infringement. Example: playing a copyrighted song in a public event, restaurant, or bar without obtaining the necessary licensing. 3. Infringement of copyright. This is a broad term encompassing any act that violates the exclusive rights of the copyright owner, including unauthorized reproduction, distribution, or use of the work. Example: using a copyrighted image in a commercial ad without permission. 4. Distributing copies for trade or affecting the market. Distributing copies of a work for commercial purposes or in a way that affects the market for the original work, thereby prejudicing the interests of the copyright holder, is considered an infringement. Example: selling pirated versions of a software program. 5. Prejudicing the interests of the copyright owner. Any act that hinders or prejudices the copyright holder's ability to benefit from their work is considered infringement. Example: posting a copyrighted movie on a website for free download, thus depriving the owner of potential revenue from sales or licensing. 6. Public exhibition of copies by way of trade. Publicly exhibiting copies of a copyrighted work in a way that suggests commercial activity or trade without authorization. Example: displaying copyrighted artwork in a public gallery or selling it as part of a trade event without proper permission. 7. Importation of infringing copies into India. Importing copies of a work that were produced without the permission of the copyright holder and are illegal in the country where they were made, and then selling them in India is an infringement. Example: importing pirated DVDs or counterfeit software from abroad and selling them in the Indian market. 8. Adapting, translating, or creating derivative works without permission. Creating derivative works, such as a translation, adaptation, or arrangement of a copyrighted work without the consent of the original copyright holder, is a violation. Example: translating a novel into another language and publishing it without authorization from the original author or publisher. For more detailed information, visit the official website of VMK Professionals, www.vmkpros.com, and always review the latest amendments before execution, as laws keep changing frequently. Question 47. What are the civil remedies for infringing copyright? Answer: under the Copyright Act 1957, if a person infringes the copyright in a work, the copyright owner can take civil action in a court of law to seek various remedies. The civil remedies available to a copyright holder in case of infringement are as follows. 1. Injunction. Injunction is one of the most common remedies in cases of copyright infringement. a court may issue an injunction to prevent the defendant from continuing the infringing act. There are two types of injunctions: interim, temporary injunction, issued during the pendency of the case to stop further infringement. Permanent injunction, issued after the court has decided the case, preventing further infringement permanently. Example, a court may issue an injunction preventing the defendant from selling pirated copies of a film. 2. Damages. The copyright owner can claim damages for the harm suffered due to the infringement of their rights. There are two types of damages that the court may award. Actual damages, compensation for the actual loss suffered by the copyright owner due to the infringement, e.g., loss of sales or revenue. Statutory damages. In some cases, the court may award predetermined damages, even if the actual loss isn't clearly quantifiable. This is to serve as a deterrent against infringement. Example, if a person sells unauthorized copies of a copyrighted book, the copyright holder can claim compensation for lost sales and market damage. 3. Accounts of profits. In addition to or instead of damages, the copyright owner can seek an account of profits. This means that the infringer must pay the profits that they made from the infringement, even if no actual loss was suffered by the copyright owner. Example, if a person infringes the copyright of a music track and makes money by selling it, the copyright owner can claim the profits the infringer earned from the sale of the unauthorized copies. 4. Delivery up of infringing copies. The copyright holder can request that the infringing copies of the work be delivered up, surrendered to the copyright holder, or destroyed. This remedy helps prevent further distribution of the infringing copies. Example, a court may order the infringer to hand over all pirated DVDs or counterfeit software copies for destruction. 5. Court orders for destruction of infringing copies. In addition to delivering up the infringing copies, the court can order the destruction of the infringing works, including any equipment or materials used to make the infringing copies. Example, if a counterfeit book or music CD is found, the court can order that all pirated copies be destroyed to stop further sale. Question 48. Which court have jurisdiction over civil remedies in copyright cases? Answer. Under the Copyright Act, 1957, the jurisdiction for civil suits related to copyright infringement is as follows. 1. District Court. The District Court has jurisdiction to hear and decide civil suits concerning copyright infringement. These suits are filed in the District Court that has territorial jurisdiction over the area where the infringement has occurred or where the defendant resides or carries on business. The District Court is the first court for hearing such cases, unless the matter falls under the jurisdiction of a higher court. 2. High Court for appeals and specialized cases. If a party is dissatisfied with the judgment or order passed by the District Court, they may appeal to the High Court of the respective state or union territory. In addition, the High Court has original jurisdiction in certain cases of copyright infringement if the case involves matters of national importance or specific circumstances as provided by law. The Delhi High Court, in particular, is known for dealing with a significant number of copyright infringement cases due to its jurisdiction over the national capital and its specialization in intellectual property matters. Specialized intellectual property tribunals in future. Though not yet fully implemented, there are provisions under the intellectual property IP laws that may lead to the creation of specialized IP tribunals in the future. These would handle cases of copyright infringement along with other IP-related matters. Question 49. Whether infringement of a copyright is a criminal offense? Answer. Yes, the infringement of copyright is a criminal offense under the Copyright Act, 1957. As per Section 63 of the Copyright Act, any person who knowingly infringes or abets the infringement of the copyright in any work commits a criminal offense. Details of the criminal offense. 1. Types of infringement. The criminal offense applies to both direct infringement, when a person personally infringes the copyright, and abetment of infringement, when a person helps or encourages another to infringe. This could include various forms of infringement such as piracy, reproducing and distributing pirated copies of books, movies, software, music, etc. Unauthorized performance, performing or broadcasting a copyrighted work without permission. 2. Penalties. O. Imprisonment. A person found guilty of copyright infringement may be punished with imprisonment, which can range from 6 months to 3 years. O. Fine. The court may also impose a fine, which could range from Rs. 50,000 to Rs. 2,000. O. In some cases, both imprisonment and fines may be imposed. 3. Prosecution process. O. The criminal proceedings are initiated on a complaint made by the copyright owner or their authorized agent. The police or appropriate authorities can take action against the infringement and initiate prosecution. Search and seizure. Authorities have the right to conduct searches and seize infringing copies under Section 64 of the Copyright Act. Number 4. Protection for copyright owners. O. The criminal provisions under the Copyright Act are designed to protect the interests of copyright holders by deterring unauthorized use and ensuring that infringers are held accountable. If you want to register a copyright for your work, contact VMK Professionals today. We'll help you protect your creativity with a smooth and hassle-free process. Visit www.vmkpros.com or call us now to get started. That's it for today's video. We hope you learned something new and valuable. If this helped you, share your thoughts in the comments and tell us about your experience with copyright or any questions you have. And don't forget to like, share, and subscribe to our channel for more legal tips and updates. Thank you.